Good morning, everyone. Hi, my name is Celia Suzuki, and I am the licensing administrator for the Professional and Vocational Licensing Division of the State Department of Commerce and Consumer Affairs. Welcome to today's orientation for PVL's board and commission members. Our last PVL orientation was held 2 years ago, and since it turned out to be a successful event, Director Catherine Awakuni Colón and Deputy Director Joanne Uchida Takeuchi felt that it was a great idea to have another one scheduled for this year. Thus, here we are today. I'm glad that you were able to take time off from your very busy schedules to attend today's session. I would like to extend my thank yous to the speakers in advance of the presentations. Before we get started, I do have a couple of important announcements to make. There are restrooms located to the left and to the right of the lobby area. We also have available for you some bottled water, coffee, and light refreshments, so please help yourselves. You are not, however, allowed to bring food and drink into the auditorium, unfortunately. Just to let you know, this morning's session will be videotaped by Olelo, channel 49. Additionally, it will be aired or rebroadcasted on September 7th, 12th, 13th, 14th. And we can email you the dates if you are interested. We invited you here today to learn more about your roles as board members and to become familiarized with ethics in government, the Sunshine Law, your role as board members, the Uniform Information Practices Act, and handling complaints. We will be hearing from the experts on the various subject matters. We assure you that the session will be very informative. We want to thank you all for all the time and energy you spend serving on the various boards and commissions and on a voluntary basis on top of that. So we really appreciate it. I would also like to acknowledge and thank the staff of the division, as they are responsible for enabling you to ensure positive outcomes for your professions, vocations, and the consuming public. I would like to share with you a little bit of information about the division, the Professional Vocational Licensing Division. Hi, Alani. There are 4 branches within the division. We have an examination branch, the licensing branch, real estate branch, and the administration branch. The administration branch serves as a liaison between the director of the department and the 25 boards and 24 regulatory programs administratively attached to the division. The administration branch also oversees licensing and examination activities and guides and assists regulatory compliance issues. The same activities are done for the 24 programs on behalf of the director of the department. Again, I thank you for your attendance at today's session. And I would like to present the first speaker and the second speaker, but they are not here yet. That would be the director and the deputy director. But perhaps we can, since Susan Yoza is here from the Ethics Commission, we'll go ahead with Susan's presentation. Thank you, Susan.
Good morning. I was told that the board members that would be attending this session this morning are the most ethical members of the DCCA boards and commissions, so I'm going to put you to the test and see. So I've been asked to talk about ethics for state board and commission members. In Hawaii, all elected, I'm sorry. How do I advance my power? I'm going to be your slide. Okay. Okay, next slide. Thank Thank you. Okay, so in Hawaii, all elected and appointed state officials and employees are required to adhere to a code of ethical conduct, which is called the State Ethics Code. And the Hawaii State Ethics Commission administers the State Ethics Code. For those of you who are perhaps not familiar with our agency, we are a state government agency. We have a 5-member commission and a staff of 10 full-time state employees. So it's our job to administer the State Ethics Code. Next slide. The State Ethics Code consists of state laws that are found in Chapter 84 of the Hawaii Revised Statutes. And the purpose of the ethics laws is to preserve high standards of integrity and ethical conduct in state government. Next slide. So these principles are embodied in Hawaii's state constitution, which states that public officials must exhibit the highest standards of ethical conduct. And these standards are set forth in the State Ethics Code, which has been adopted by the legislature as state law. Now, as I go through and explain some of the provisions of the Ethics Code to you this morning, please don't think that the State Ethics Commission assumes that all state officials are unethical. You are all to be commended for volunteering to serve as board and commission members. We know that you are doing this in the spirit of public service, and that you all intend to conduct yourselves honorably and with integrity. But the Ethics Code is based on the desire to preserve public confidence in government. So in accordance with the state constitution, public officials are required to exhibit the highest standards of ethical conduct. And that's why we have a code of conduct for state government officials. Next. The State Ethics Code applies to all state employees, to all state legislators, and to the members of all state boards and commissions. So all of you present here today must follow the State Ethics Code. Next. Any state official who violates the State Ethics Code is subject to certain penalties that are provided for by law, and this includes disciplinary action. The state can recover any illegal gifts, fees, or profits. State contracts or any favorable state action that's obtained in violation of the Ethics Code can be voided by the state, and the Ethics Commission has the authority to assess administrative fines of up to $500 for each violation of the Ethics Code. The Hawaii State Ethics Commission has a constitutional mandate to administer the State Ethics Code, and we do this by giving ethics advice to state officials such as yourselves. We investigate violations of the State Ethics Code. We conduct educational presentations on ethics in government, and we administer disclosure laws that are found in the State Ethics Code. Probably our most important function is to educate and advise state officials about the ethics laws. Please remember that if you ever have a question about the Ethics Code, you can easily contact our office to request advice. One of our attorneys will speak to you about your situation and can give you advice over the telephone, or if you want something in writing, you can request that, and we will provide you with written advice about your situation. So I'd like to encourage all of you at any time to feel free to contact our office to discuss any ethics questions or concerns that you may have. Okay, I'm going to just say a word about financial disclosure statements. Many of you probably first became aware and acquainted with our agency when we asked you to file a financial disclosure statement with us. And this is required by law for about 1,800 state government officials, including the members of most state boards and commissions. Most of the board filings are confidential. Board members are required to file an initial disclosure statement with our office within 30 days of their appointment, and then every year after that by May 31. So what will happen is that every year you'll receive a reminder memorandum from our office letting you know that it's time for you to submit your annual financial disclosure statement. All of the forms and instructions are available on our website, and you can complete the forms and file them online. So we appreciate your cooperation in filing your financial disclosure statements on time. And again, if you have any questions or need help filling out the form, please don't hesitate to contact our office. Okay, next slide. So I'm going to talk today about some of the subject areas that are in the State Ethics Code. And the Ethics Code covers a number of different areas, including conflicts of interest, gifts, confidential information, something that we call fair treatment, which has to do with the use of your government position or office, state contracts, and post-employment restrictions. For today, I'm going to be focusing on the areas that probably are most relevant for board and commission members. So that has to do with conflicts of interest, gifts, and fair treatment. So let's look at the first hypothetical that we have. And I'm going to be using some of these hypothetical cases to illustrate how the ethics law applies to you. In this first situation, we have Sandy, who's a member of the State Board of Public Health. The board issues health permits to restaurants. At its next meeting, the board is scheduled to review a permit application from Kohala Steakhouse. Can Sandy participate in the board's review of this application in the following situations? A, Sandy's husband is employed as a chef at Kohala Steakhouse. And B, Sandy's daughter is part owner of Kohala Steakhouse. So let's see how the Ethics Code applies in these situations. Next slide. Probably the most frequent ethics question that we receive regarding board and commission members has to do with conflicts of interest. So I'm going to spend some time this morning talking to you about the laws in the Ethics Code that have to do with conflicts. And there are 3 conflict of interest laws that I'll be covering with you. The first says that a board member cannot take official action directly affecting a business in which the board member has a financial interest. So in other words, if you have a financial interest in a business, you are prohibited from taking official action as a board member affecting that business. The law requires you to disqualify yourself in that situation and abstain from participating in board action on the matter. Now, this conflict of interest law is triggered whenever a board member has a financial interest in a business. And let's see how the term financial interest is defined under the law. Financial interest includes all of these different types of interest: ownership interest in a business, employment, serving as an officer or director in a business, ownership of property, loans, and being a creditor in an insolvent business. Most conflict of interest situations that come before our office involve the first 3 types of financial interest. So it's usually a state official who has an ownership interest in a business, is employed by a business, or is serving as an officer or director of a business. It's important to know that for purposes of the State Ethics Code, a business includes both for-profit and not-for-profit organizations and businesses. And it's also important to know that under the Ethics Code, a board member's financial interests includes the financial interests of their spouse, and if they have any dependent children, it includes the financial interests of their dependent children. So what all of this means is that if you or your spouse or a dependent child of yours has a financial interest in a business, the Ethics Code prohibits you from taking official action as a board member affecting that business. Now, what does it mean when we say you're prohibited from taking official action on a matter? Again, that's a term that's defined in the law. That's the next slide. Official action includes a decision, recommendation, approval or disapproval, or any other action that involves the exercise of discretionary authority. For board members, you should remember that official action includes not just voting on a matter, but also participating in any board discussions or deliberations leading up to a vote. So if you have a conflict of interest, you have to abstain from taking any official action as a board member in that matter. Okay, let's go back to the first hypothetical that we had involving Sandy. So with respect to the first question, can Sandy participate in the board's review of this matter if her husband is employed as a chef at Kohala Steakhouse? What do you think? No, I see head shaking. You're correct. She cannot participate in this matter. And let's do the conflicts of interest analysis here. First of all, her husband is employed by Kohala Steakhouse, which is a business. And because he has an employment with this business, her husband has a financial interest in this business. His financial interests are going to be considered part of Sandy's financial interests, so that means Sandy has to disqualify herself from taking action as a board member affecting this business. Okay, what about the second situation? Can Sandy participate in this matter if her daughter is part owner of Kohala Steakhouse? Okay, let's do the analysis here now. Her daughter has an ownership interest in Kohala Steakhouse, and remember we said under the law, an ownership of a business is a financial interest. So her daughter has a financial interest in this business. But is the daughter's financial interest considered part of Sandy's financial interest? Yes, that's a good question. Is she a dependent? When we talk about dependent child in the ethics code, normally we mean dependent for tax purposes. And so under the law, your dependent child's financial interests are considered part of your interests. But your emancipated or adult children who are not your dependents, their financial interests are not considered part of yours. So in this situation, it's unlikely that Sandy's daughter is a dependent child of hers. So let's assume that the daughter is an emancipated adult child. That means that although her daughter has a financial interest because she's a part owner of this business, her financial interests are not going to be considered part of Sandy's financial interests. So what that means is that technically Sandy does not have a conflict of interest under the state ethics code, and she's not required by the ethics code to disqualify herself from taking action in this matter. Now, there is another section of the law that I'll be talking about in a few minutes, and that's what we call our fair treatment law. That law basically prohibits a state official from giving preferential treatment to anyone. So in this situation, if Sandy decides that she is going to go ahead and participate in the review of this matter, she's prohibited from using her position as a board member to give her daughter's business any preferential treatment. In this kind of a situation, if Sandy had contacted our office to ask for advice, we would have explained to her that she technically does not have a conflict of interest, but I think we also would advise Sandy that she may wish to consider voluntarily disqualifying herself from participating in this matter. And many employees and board members will do this just to avoid any appearance of a conflict of interest or any possibility that someone's going to claim you're using your state position to give preferential treatment to anyone. So voluntary recusal is a possibility in this case if Sandy just wants to avoid any questions at all. Okay, let's go on to the next slide. There is a special provision that applies to board members who by law are appointed to represent particular professions or industries on their boards. And this applies to a lot of board members in the Department of Commerce and Consumer Affairs. So for example, there's a law that establishes the Real Estate Commission, and that law requires that a certain number of members of the commission must be licensed real estate brokers. We sometimes refer to those board members as expert board members or mandated board members because the law requires them to have certain qualifications in order to serve on the board. The conflict of interest law allows these expert board members to take official action affecting their professions or their industries as a whole, but it prohibits them from taking official action that specifically affects their own businesses. So let me give you an example of that. Let's say I'm a member of the Real Estate Commission. I've been appointed to the commission because I am a real estate broker. I can participate in board action affecting all of the members of my profession. For example, I can participate in the board's adoption of rules that will affect all real estate brokers, including my own business as a real estate broker. So it's not a prohibited conflict for me to participate in that kind of action. But if someone files a complaint against my business and that complaint comes before my board, That's a situation where I cannot participate in board action on that matter because that is going to specifically affect my own business. So I would have a conflict of interest in that situation, and I would be required to disqualify myself from participating as a board member. This can be somewhat complicated, and so our suggestion is to those of you who are the expert board members serving on your boards or commissions, if you have a question about conflicts of interest, it's always best to call our office and we can discuss your situation with you. Okay, let's go on to the next hypothetical. So that was the conflict of interest law that applies when board members have financial interests that may require them to abstain from taking official action. There's also a law that applies to the acquisition of new financial interests by board members. And let's take a look at this second situation. Patrick is a member of the Consumer Safety Board. The board has contracted with a consulting firm to develop a consumer survey on identity theft. The consulting firm is impressed by Patrick's expertise on consumer safety, and they invite Patrick to accept a position on the firm's board of directors. So the question here is, can Patrick accept this position? Next slide, please. The conflict of interest law that applies to this situation states that a board member cannot acquire a financial interest in a business which may be directly involved in official action to be taken by the board member. So in other words, if a board member has reason to believe that a business is going to be involved in official action to be taken by his or her board, that member cannot acquire a new financial interest in that business. The reason that we have this restriction in the law is to prevent state officials from acquiring new financial interests that are going to conflict with the performance of their official duties. So going back in the next slide to the hypothetical involving Patrick, he's been asked to accept a position on the board of directors for this firm. If he accepts this position, would he be acquiring a financial interest in this business? What do you think? Yes, I see heads nodding. Yes. Remember, serving as an officer or director for a business is considered a financial interest under the law. So by becoming a director for this business, Patrick would be acquiring a financial interest in the firm. Does Patrick have reason to believe that this business is going to be involved in official action by his board? In this situation, we would say yes, because the board has awarded a contract to this firm. So therefore, the conflict of interest law is going to prohibit Patrick from accepting a position as a director for this firm. Okay. I'm sorry, I don't have time for questions today, but I'll be available afterwards. And so if you can come and talk to me afterwards, I'd be happy to answer any questions you may have. Okay, there's a final conflict of interest provision that you should be aware of. Unfortunately, a number of board members have inadvertently run into problems under this section of the Ethics Code because they didn't realize that their actions at the time actually created a conflict for them. So it's important that you be aware of this conflict of interest law. Let's take a look at our third and final conflicts hypothetical. This involves Marcus, who's a member of the Board of Professional Licenses. Marcus is an attorney in private practice, and his board has scheduled a hearing to determine whether the license of a real estate broker should be revoked. The broker would like to hire Marcus to represent her in this matter. If Marcus abstains from taking action as a member of the board, can he represent the board at the hearing? What do you think? Not sure. Okay. Let's take a look and see what the law says. The conflict of interest law that applies here states that a board member cannot assist or represent another person for pay on a matter before the member's board or state agency. This law also prohibits a board member from being paid to represent another person on a matter in which the board member has participated or will participate as a board member. The purpose of this law is to prevent what we call influence peddling, and that's a situation in which a state official is hired to use their inside influence or their contacts within an agency to unfairly benefit others. So if we go back to the third hypothetical, the law is going to prohibit Marcus in this situation from representing a private client on a matter before his own board. Even if he disqualifies himself as a board member from taking action in this case, he cannot represent a private client before his own board. So that concludes our discussion of the 3 conflict of interest laws. I've covered the law that requires board members to disqualify themselves from taking action affecting businesses if they have a financial interest in that business. We've covered the law that prohibits the acquisition of new financial interests that are going to create a conflict for you with your state duties. And the third law that we just covered prohibits a board member from being paid to assist or represent someone else on a matter before their own board. I'm going to switch now to another important section of the State Ethics Code that perhaps is a little bit more interesting for us, and that has to do with gifts. So let's take a look at our next hypothetical. Gina is chairperson of the State Commission on Planning and Development. A private developer with business before the commission has invited Gina to play in a charity golf tournament. Can Gina accept this invitation? Okay, this is multiple choice. A, yes, because the golf tournament is for a good cause. B, yes, as long as Gina files a gifts disclosure statement with the State Ethics Commission. And C, no, this is a prohibited gift. Okay, how many of you think that this gift is okay for Gina to accept? I see no hands raised there. How many of you think there's a problem with her accepting this gift? Oh, okay, I see a few hands. Let's talk about the gifts law. The State Ethics Code has a gifts law which says that a board member cannot accept or solicit any gift if it's reasonable to infer that the gift is intended to influence or reward official action. In order to understand this law, the first thing you need to recognize is what gifts are subject to the law. Next slide. Okay, so for purposes of the State Ethics Code, gifts can come in many forms, and basically anything of value may be a gift. So this would include food, the box of cookies or candy that someone drops off at a state office, that's considered a gift. If someone takes a state official out to lunch or dinner and pays for their meal, that also is considered a gift. Entertainment can be a gift if someone gives a state official free tickets to a football game or to a special event that's being held at the convention center. That's considered a gift. Other types of gift include travel. Sometimes organizations will pay for the travel expenses for a state official to take a trip on state business. And in certain situations where these trips are going to serve a legitimate state purpose, they may be acceptable gifts under the Ethics Code. But we generally advise all state officials that if you're ever offered a free trip to be taken by you in your state capacity, you should contact our office, because the application of the gifts law to that kind of a gift is really going to depend on the circumstances. Other types of gifts that may be offered to state officials include gift certificates, discount cards, loans, money, personal services. So basically anything of value can be a gift. Okay, next slide. So if it's reasonable to infer that a gift may be intended to influence or reward a state official, the gift is prohibited under the law. We look at several factors when we apply the gifts law to a particular situation to determine whether or not the gift is prohibited. And the factors that we take into account are, first of all, the value of the gift, and usually we're looking at fair market value for this. We also consider whether the board member takes any official action affecting the donor of the gift. Gifts are more likely to be prohibited under the Ethics Code if they are coming from vendors or contractors who have business dealings with your board, or if they're coming from an individual or business that's subject to the regulatory authority of your board. And then the third factor that we look at is whether the gift is a purely personal gift, such as golf, or whether the gift provides some kind of state benefit to the official. And an example of this is if someone pays for a state official to attend a conference that's going to benefit the state official in the performance of their state duties. That may be a situation where, because there's a state benefit, it may be possible for the official to accept the gift under the ethics code. But again, it's really going to depend on the circumstances. Next slide. So we're going to go back and talk about Gina now. You may recall seeing in the news a couple of years ago that a number of state employees from various state departments were fined by the State Ethics Commission for accepting golf from state vendors and contractors. We investigated about 50 state employees, and the majority of them ended up having to pay fines to the state for accepting illegal gifts of golf. And the fines ranged from $250 all the way up to $7,500 by one state employee. So in this situation, we would advise Gina that this invitation from a company that has business before her commission is a prohibited gift, so she may not accept this invitation. Now, there's also a gifts disclosure law in the ethics code, and sometimes officials think that a gift can be accepted as long as they report it on a gifts disclosure statement to the Ethics Commission. This is incorrect. Next slide. Whenever a state official is offered a gift, the first question that should be asked is, can I accept this gift? Is this gift an acceptable gift under the state ethics code? If it can be accepted, then the second question is going to be whether it needs to be reported on a gifts disclosure statement. So reporting a gift on a gifts disclosure statement does not automatically make that gift an acceptable gift under the gifts law. Okay, next slide. I'm just going to talk real briefly about the gifts disclosure law. There's more information about this law on our website. The law basically requires a state official to file a gifts disclosure statement if 3 conditions are met. The first condition is if a board member receives a gift whose value is more than $200, or receives several gifts from the same donor, and if you add up the combined value of those gifts, it's over $200. That's the first condition. Second condition is that the source of the gift has interests that may be affected by the board member's official action. And the third condition is that the gift is not exempted from the gifts reporting requirements. Certain gifts, such as gifts from close family members or gifts that are donated to charity, are exempt from the gifts reporting law, and so they don't need to be reported. If all 3 of these conditions are met, then a board member must file a gifts disclosure statement with the State Ethics Commission. These disclosure statements are due on June 30th of every year, and forms and instructions for gifts disclosure statements are available on our website. So the application of the gifts law depends on each situation. And the best thing to do is if you are offered or if you receive a gift from anyone that you deal with in your state capacity, call our office for advice. And anytime you have a question about gifts, we'd be happy to discuss your situation with you, and we can tell you, first of all, whether it's okay for you to accept the gift, and if you do accept it, then we can also advise you whether or not you need to file a gifts disclosure statement to report it. Let's look at the last section of the Ethics Code that has to do with what we call the Fair Treatment Law. A board member asked the board's executive officer to see if the employees in the office would like to buy fundraiser tickets to benefit the board members' hula halau. Is this allowed under the Ethics Code? A, yes, as long as the executive officer does not pressure employees into buying fundraiser tickets. B, no, it would be better for the board member to send an email to the office to ask employees to buy fundraiser tickets. Or C, no, private fundraising in state offices is prohibited. Okay, let's look at the law that applies here. As I mentioned earlier, there's a fair treatment law, and this law states that a board member cannot use their official position to unfairly benefit anyone. This means that you're prohibited from using your official position to give preferential treatment or any unwarranted privileges or advantages to anyone. Next slide. The Fair Treatment Law has a number of subsections that prohibit specific types of activities, and all of these activities are considered a misuse of your state position. So that includes using your state office or position to seek other employment or contracts for yourself, accepting compensation for performing your official duties, except as provided by law, using state time, equipment, or facilities for private business purposes, and entering into substantial financial transactions with subordinates or persons or businesses that you inspect or supervise. The section of the law that seems to be the most problematic for state offices is this third section, using state time, equipment, or facilities for private business purposes. This section prohibits state officials from using state resources for any private business activity. And so this would include private sales transactions. It also includes private fundraising, and it also includes campaign activities. So over the years, we've received complaints about employees doing all kinds of private business activities in their state offices. There's been selling crafts or food in state offices. We've had employees using state work time and other state resources for campaign activities. We've also had state employees using state vehicles for private business activities. We had one complaint that a state employee was using a state vehicle, driving it from state office to state office and selling lau lau out of the trunk of that car. Okay, so these are all considered prohibited private business activities. So if we go back to our board member in this situation, the answer is C. Private fundraising in state offices is prohibited, so the board member should not be trying to sell fundraiser tickets to the employees in this state office. As board members, you also need to be careful not to misuse your official positions or authority in your dealings with the board staff that works with you or that works for you. So as shown in this case, asking a staff member to perform fundraising or other private business activities at work is considered a misuse of your official position. So we've covered today conflicts of interest, gifts, and fair treatment. I didn't have time to go over all of the ethics code provisions, but we do have more information on our website about the state ethics code. We also have a special publication about the ethics laws for board and commission members, and we're in the process of updating that publication now. It's going to be posted on our website sometime this week. So if you check back with our website later this week, you should be able to access this publication. Okay, last slide. So here's our contact information again. I know I've given you a lot of information in a short amount of time. The most important thing for you to remember is that the Ethics Commission is available to assist you and to answer any questions that you may have about the Ethics Code. Don't hesitate to contact our office and ask for advice. So thank you very much for your attention, and thank you again for your public service.
Thank you, Susan. Susan is the Associate Director of the State Ethics Commission. At this time, I would like to introduce our Director of the Department of Commerce and Consumer Affairs, Catherine Awakuni Colón. She'll be saying a few words to you.
Thank you, and apologies for the lateness of our arrival. We were doing emergency planning calls, tracking the 2 latest hurricanes. So make sure you have your water and your batteries and your canned goods. But thank you for volunteering to provide your service and for coming to the training today. I also want to thank Celia Suzuki and her team for putting together the training for you. I think it's really important for all of the board members that you have a full understanding of what it is that you're being expected to do. So as Celia was mentioning, I'm Catherine Awakuni Colón. I go by Cat. Feel free to call me Cat. I'm the director, and I've been in the position since January of 2015. I'll just point out a couple of people from the director's office. So Will New is our communications officer for the department, and Sean Michael is in the back. He's the assistant in the director's office, and he's our legislative coordinator. I think you're going to find that you're lucky that your boards and commissions are attached to DCCA, because we really do have excellent staff. We at DCCA and the AG's office are your partners in this process, and I think you'll find that DCCA really does strive to find that right balance between giving your boards and commissions the independence it needs with the appropriate amount of supervision and assistance. And so your EOs, your executive officers really are kind of the in the trenches folks who know your boards and commissions best. And so I urge you to rely on them. The deputy AGs who are assigned to our boards and commissions are very experienced. We're very lucky to have them, and so I think rely on them as well. And if ever you need additional help, I think Celia Suzuki is a good resource. You can always call me. Don't hesitate. So you can always reach out to me at the director's office if you need help as well. So we're totally willing to help you in this process. Again, we are your partners. Please also remember that you guys will be examples in your industry. Others in your field are going to be looking to you to see how you conduct yourselves when they are trying to determine how they should be conducting themselves. And so just want to remind you too that you will be those kind of shining examples of what it means to be a model chiropractor or contractor or whatever it may be. So extra weight, I know, but just again, wanted to thank you for your service and your willingness to help us, your industries, and our community to make sure that we're all, taken care of. And again, if you ever have need, feel free to reach out to Director's Office. Thank you so much.
Whoa, look how high this mic is. Thank you, Director Awakuni Colón. At this time, I would like to call up the Supervising Attorney General for the Commerce Economic Development Division of the Department of the Attorney General, Attorney Bryan Yee. Thank you.
Ooh, look how low it is. Good morning. My name is Bryan Yee. I'm the Supervising Deputy Attorney General. Just to let you know, there's an Attorney General, and then there's all of us down below. I am the Deputy Attorney General for the Commerce and Economic Development Division. We provide legal support for DCCA, including its various boards and commissions. First of all, let me thank all of you who are volunteering to be on a board. The state does rely on your service. We rely on people to be willing to donate their time, their energy, their enthusiasm, and their expertise for government to run well. I also understand that I'm the only thing standing between you and your first break, so I will try not to take too much of your time. But today I was asked to provide a little bit of information about a case called North Carolina State Board of Dental Examiners versus FTC. This is an example of a case that came up recently, which has caused a lot of discussion among various boards and commissions across the nation as to the meaning and the applicability of the state action immunity from antitrust lawsuits. It's a relatively new case. It was in 2015, and cases interpreting the Supreme Court decision are still making its way through the courts. Consequently, a number of us are still looking through the wording of the case and guidance from the FTC, as well as our own judgment in order to try to best understand how this will apply. A discussion of this case today will just be one of the legal issues that you may be facing as a board or commission member, but it's a good example perhaps of the kind of thing that your deputy might be talking with you about, or at least give you some base understanding of the issues so that you could talk with your deputy on particular issues in greater depth and comprehensiveness. I will note that because there are a number of things that we don't know yet about the case, I'm going to try to talk about the things we do know. And if questions arise in a particular matter, I certainly urge you to consult with your Deputy Attorney General, who will be present at each one of your board meetings. I also should tell you that I'm advised that this matter may be recorded. So at the outset, I have to say that this is my presentation. It is not an official advice letter from the Department of the Attorney General. It does not necessarily represent the position of the Department of the Attorney General. Nothing I'm saying here should be considered legal advice. The public is not my client. In fact, I am legally prohibited from providing legal services to individual members of the public, including the various industries regulated by DCCA. So first of all, as I move forward with the actual substance of this, is there anyone on the board of the Hawaii Hurricane Relief Fund? If you are, this actually won't apply to you because the North Carolina Dental Board case applies to those boards or commissions which are populated by a controlling number of active market participants. And the Hawaii Hurricane Relief Fund just doesn't have active market participants on it. Consequently, their concerns about the antitrust immunity are alleviated since they are so clearly a state agency. But it does apply to the various professional and vocational licensing boards of DCCA, which have a controlling number of active market participants. And the test set out by the Supreme Court, as shown in the first slide, is that a board is immune from antitrust claims if the challenge restraint was, one, clearly articulated and affirmatively expressed as a state policy, and two, the policy was actively supervised by the state. Now, you should first understand that professional and vocational licensing laws inherently restrict competition. Its purpose is to restrict competition to those individuals deemed qualified to perform certain services. This creates an inherent tension between the federal antitrust laws and the state licensing laws, as the federal government is certainly empowered to regulate antitrust, and the states, by the same token, are also empowered to regulate its various industries. In part, this tension is eased by the recognition that the sovereign actions of the state may be immune from antitrust claims subject to certain limitations. Parker versus Brown is sort of the seminal case on this matter, which set forth the clear understanding that pure state actions are immune from antitrust claims. So, for example, if the legislature passes a statute which some might think inherently restricts competition, there is no federal antitrust claim against that. With respect to licensing boards in Hawaii, however, we note, or the court has noted, that the states delegate this sovereign authority to market participants. With respect to these licensing boards, antitrust immunity is only afforded if, as it says on the slide, the challenge restraint was clearly articulated and affirmatively expressed as state policy, and two, the policy was actively supervised by the state. Next slide. With respect to clear articulation, the various state statutes regulating the various professions and trades, we believe, constitute the clear articulation and affirmative expression of state policy. Consequently, provided that the licensing board acts within what is generally broad authority to regulate the profession, the board will generally be able to satisfy this prong of the test. It is probable that this is not going to be the difficulty in meeting the Supreme Court test set forth. The second prong is a little more problematic, and that involves active supervision. Now, the court has stated that active supervision requires more than a facade of state involvement. It is necessary to ensure that a state is politically accountable for the anti-competitive conduct, but the test should be flexible and content-dependent and does not require a day-to-day involvement in the agency's operations or micromanagement of its every decision. So what does it mean? Well, as I said, the courts are still working its way, or the decisions are still working its way through the courts. But the FTC, which had argued for this position, set out its guidance of what it believes to be a guidance on how this test is to be applied. Understanding that this is a position of the FTC and not the U.S. Supreme Court, it is nevertheless important to understand, since the FTC is the one most likely to take the first position as to whether an action is or is not a violation of federal antitrust law. Next slide. The Federal Trade Commission has issued additional guidance. And they started by saying, just because a board does not possess antitrust immunity does not mean that every action of the board is a violation of the antitrust laws. And they identified 3 categories of action which do not constitute antitrust violations. The first is reasonable restraint on competition. So while the antitrust laws may prohibit the unreasonable restraint on competition, a reasonable restraint of competition is all right. The 2 examples that they have given are prohibiting licensees from engaging in fraudulent business practices or prohibiting them from engaging in untruthful or deceptive advertising, hence the issue of boneless chicken being eggs. Some might think that this is very simple. Of course, you can prohibit unlawful advertising or deceptive advertising, but it also gives you an idea of the reach of the term restraint on trade. The second example they have given is suspending the license of one electrician in a market of several hundred electricians for substandard work would likely not unreasonably harm competition. This will probably be more important as you get down to the individual disciplinary cases where if you have one case, that single case probably does not constitute an unreasonable restraint on trade. A pattern and practice in which a series of cases are brought may be more problematic. And again, you should consult with your Deputy Attorney General. The second issue involves ministerial acts of the board in good faith implementation of a statutory regime. The example that the FTC gave is the denial of a license for failing to submit the required fee. This is not a judgment call. They either submitted the fee or they did not. The requirement of the fee is set forth in either the statute or the rules. Consequently, the decision to deny the applicant in this particular case is not an unreasonable restraint on trade. It is simply the ministerial act of the board in good faith. The third is the good faith initiation and prosecution of a lawsuit in circuit court. The idea is that you are appearing in front of a court, not as the decision maker, but as the applicant. So, for example, if a board was to file a petition for declaratory relief or injunctive relief, if they wanted to enforce a particular decision, that particular filing would not constitute an unreasonable restraint on trade because the court is the decision maker, not the board. Obviously, you may come up with many other examples which are more difficult, involving less clear issues. And your Deputy AG will be available to discuss the matter and what the risks would be for any particular decision. Next slide. Active supervision is, as I said, probably the most important issue or prong in the test. Now, the FTC cited a variety of principles that they would follow, but they also cited to several factors which they said were relevant to their determination of whether the active supervision requirement has been satisfied. The first is whether the supervisor has obtained the information necessary for the proper evaluation of the action recommended by the regulatory board. The amount of information gathering, they said, is dependent upon the particular facts of the situation. The second is whether the supervisor has evaluated the substantive merits of the recommended action and assessed whether the recommended action comports with the standards established by the state legislature. And the third is whether the supervisor has issued a written decision approving, modifying, or disapproving the recommended action and explaining the reasons and rationale for such a decision. Now, as you apply this test, the example I'll start with is rulemaking. The board will adopt rules, and they will consider, may amend, and then eventually propose rules to go out to public hearing. It goes out to public hearing, the public will comment. Normally, the public comments will be gathered, answers or responses will be written out. The board will then consider whether or not they want to make any changes. Those amended rules after public hearing are then adopted and sent to the governor. The governor must approve the rules before those rules can be effective. So the issue or the analysis is whether the role of the governor is active supervision under the federal antitrust laws as set forth by the Supreme Court and as guided by the FTC. So when you apply these three standards or factors that I recited, you'd look at first, as I said, the first was, did the supervisor evaluate the substantive merits? And in this particular case, you would look at whether the state obtained the information necessary for the proper evaluation of the proposed rules. You would look at the fact that you went out to public hearing, whether or not you relied on any published studies, and any other factual information the governor may have relied upon. The second is, did the state evaluate the substantive merits of the recommended action? For example, you would look at whether DCCA looked substantively at the rules recommended by the board, whether Budget and Finance did the same, whether the Attorney General's office did the same, which is standard practice in the state of Hawaii. The third was whether a written decision was issued. Now, I will say normally a written judicial decision does not come with the promulgation of rules from the governor's office. But I will also note that after the public hearing, it is common practice for the comments to be written out with written responses then being created mostly with your DCCA executive officer. And that, I think, would be a factor that we would submit to the FTC in arguing to them that the adoption of rules is not, the adoption of the rules and the approval by the governor constituted active supervision so that those rules are not subject to the antitrust laws of the federal government. Next slide. The FTC also noted certain things which they said were not active supervision. And the first are state employees participating in the deliberations but lacking the authority to disapprove the anti-competitive acts. This probably refers to your EO. You will have an individual assigned to each board and commission that is going to be very, very helpful. They've been with DCCA for sometimes decades. They have an institutional memory and knowledge of what the board has done, their past practices. They can cite to you the rules. They know what the rules are. They are very, very helpful. But they are not the board. They don't vote. They don't make decisions. It is up to you to make the decision. Consequently, as helpful and as important as the EO is, their involvement in your matters does not constitute active supervision. The second thing they talked about is an attorney who provides advice to the regulatory board on an ongoing basis. So you again will have a deputy attorney general at all of your board meetings. You can ask them any legal questions. We will work with you to help you do your job. But that deputy AG does not have, or generally would not constitute active supervision sufficient to shield the board from antitrust violations. There's a lot that we don't know. There's a lot that is still being set out. And in individual cases, the likelihood is this issue will not occur for you so very, very often. And when it does, there will be a deputy AG to consult with. But, next slide, if you are sued, we certainly understand that you are providing a public service. And we ask a lot from all of you in doing so. So you may be a little concerned about liability, and I just wanted to point out that first, HRS section 26-35.5C provides for indemnity from federal claims unless the damages are fully covered by a policy of insurance purchased by the state or is caused by an action or inaction to effect a malicious or improper purpose. So assuming you're not on the board attempting to effect a malicious or improper purpose, the fact that you may make a mistake doesn't necessarily mean that you'll be subject to personal liability. that the state will has agreed by statute to indemnify you for any damages that may be assessed against you. This is actually a little different than what's applicable to state employees. State employees, for example, if I go out, I commit some type of tort as a state employee, and I am sued for the actions done in the course and scope of my employment. Although it's true the state may be liable, so am I, or I may be potentially liable. There is no state statute that actually promises to indemnify me for my actions. The promise to indemnify me for any damages that are assessed against me. Historically, the state has done so because it tries to protect its state employees from mistakes done with a good faith action on their part, but it's not actually guaranteed. For board members, it's guaranteed. In addition, we'll also pay for a deputy attorney general to represent you. So HRS section 26-35.5E allows the Department of the Attorney General to represent you if you are sued. While you certainly may hire your own private counsel if you're willing to pay for it, and sometimes some people have homeowners insurance that allows them to do that, we certainly understand that hiring an attorney itself can be very expensive. So this is a promise that we have made to boards and commission members that if you are sued, and assuming you have not done something for a malicious or improper purpose, representation will be provided for you. So as I said, our office will be at your board meetings to advise you on these and other legal matters. We are there to assist you, to be part of the team, to help you do what you need to do. So thank you for your service, and I'm available for any questions. If not, one question. Yes. Well, in the North Carolina dental case, you had a state dental board which were populated by people who were elected, but who had to be dentists. So you populated this board by an election of dentists. And the dentists then decided that using teeth whitening kits, like crest whitening, was going to be a violation if you were not a licensed dentist. They sent out the cease and desist letter to all these organizations that were selling these crest white strips and threatening them, basically saying, you are violating state licensing laws. How dare you do that? We are going to prosecute you. And that went up to the US Supreme Court. And the argument that the dental board brought up was, hey, we're a state agency, can't sue us. And the Supreme Court said, no, you are a bunch of dentists, basically. Yes, you were elected. Yes, you have the imprimatur of a state agency, but you are not being supervised by any other state actor. You're doing this on your own. You are all active market participants. They're all dentists, basically restricting competition so that only licensed dentists could sell these teeth whitening strips. And so the Supreme Court said, you don't get the antitrust immunity that we give to the states. I will note, you're asking a slightly broader question, different state agencies will have different levels of protection. So for example, a legislator which passes a law, you don't ask if there's active supervision. The legislature, is exercising what is such a supremely sovereign action of the state that you don't have to go past the fact that they passed the law. That's what legislators do. That is a state action. Done. Don't even go to court. So there are different levels that occur. With respect to boards and commissions, they've imposed this two-pronged test, which, as you can sort of hear from what I'm saying, some things are going to be clear, some things not as clear. And so we're going to have to work a little bit about that when you come across individual cases. Now, I will say generally, in my relatively recent experience, so it hasn't been sort of maybe decades and decades, but the boards have been, I think, really working in good faith to do what they think is the law says. So I don't think, I haven't seen attempts by the board to sort of overstep or to really just protect their kuleana so strongly to the detriment of competition from consumers. I think the dental board recently sent out a letter saying selling teeth whitening kits is okay. You don't need a license to do it. So I haven't seen that action. So I'm not, so I don't know that there's a likelihood of an antitrust case being brought. But, the North Carolina Dental Board case is relatively new, and we need to keep abreast of these things and be aware of these potential risks, and so that we can advise you and you can be aware of the potential risks, so you can ask us if you think there's any concern. Sorry, I kind of went off topic a little bit. If nothing else, I just want to thank you and have a good day.
Thank you, Bryan. At this time, let me see. I would like to introduce State Senator Ross Baker, who will be back later. Hi, Senator. Thank you. Okay. Thank you. We'll see you later. We are slightly ahead of schedule, but let's take a 15-minute break right now. Thank you. At this time, I'd like to introduce our Deputy Director of the Department of Commerce and Consumer Affairs, Joanne Uchida Takeuchi. She's seated in the last row. Thanks for coming. I would also like to introduce some of our executive officers who are here this morning. Christine Rutkowski. Hi, Chris. Alani Kiyoki. Alan Taniguchi, Carol Kramer. Thank you, Carol. And May Ferrer in the back. Thank you. Okay, our next presenter is the Complaints and Enforcement Officer, Daria Goto from the Regulated Industries Complaints Office. Thanks, Daria.
Good morning. Once again, my name is Daria Goto with the Regulated Industries Complaints Office. Acronym is RICO, not racketeering and organized crime. In case you get confused, in the long time that I've been with RICO, I can tell you I still get phone calls from people because they are looking for a very different office than ours. Okay, just to give you a little bit of perspective about the Regulated Industries Complaints Office. RICO handles receipt of complaints, investigation, and prosecution on behalf of all 49 boards, commissions, and programs that are administratively attached to the Department of Commerce and Consumer Affairs. We have offices on Maui, Kauai, and in Hilo and Kona. We're mostly comprised of clerical, intake investigators, field investigators, and attorneys. We are funded by compliance resolution fund fees. To give you a brief perspective of the 49 different licensing areas that RICO oversees, many of the areas that we cover are going to be encompassed in healthcare. The other boards and commissions are laid out on the tiles that you can see on the RICO website. I like to say that we are jacks of all trade and masters of none. Our jurisdiction is broad and it's deep. We cover contracting, like I said, healthcare industries, mixed martial arts, boxing, cosmetology, massage therapy, engineers, architects, land surveyors. So ask us anything about anything that we do, and I can tell you that one of the most fascinating things about working at RICO is the amount of subject matter that we cover and how interesting and varied the professions are that we deal with. All right, so let's talk a little bit about what a regulated industry is. Under Hawaii state law, the regulation and licensing of professions and vocations is undertaken when reasonably necessary to protect health, safety, or welfare of consumers of the services. That's found in Hawaii revised statutes. Most people in the state don't actually realize that a license is required for many industries. We know that from a variety of sources, one of which is the work that we do at the home shows for contracting a new home building. On the presentations that we give to consumers, people always have notepads. People are always taking notes when we talk about licensing requirements in the state. So a lot of what we do is pushing that education piece to consumers. In terms of consumer protection, it is much easier and more effective for us to be able to prevent a consumer from entering into a contract with an unlicensed contractor, for example, than it is to try and recoup or take action against the unlicensed contractor after the $40,000 has already been paid. So a lot of what we do in terms of what our office does is the education piece, and the education piece for consumers, and that consumer prevention piece. Hopefully, consumers get the message that a license is required, like I said, in the 49 different areas that we talked about. And so that's why the RICO website is set up that way. That's why we make ourselves available to any consumer group who is interested in hearing the hire a licensed contractor or other licensing area messages that we put out. There are common misconceptions about licensure. A lot of times consumers will think that a licensed practical nurse requires more schooling than a registered nurse because there are more letters in the acronym. A lot of times consumers are confused that a contractor's license does not include plumber's licenses or electrician's licenses or even engineering licenses. So again, a lot of what we're doing is the consumer education piece about the importance of hiring a licensed contractor or licensee. To give you some idea of where RICO falls in the Department of Commerce and Consumer Affairs layout, you'll see RICO over on the right-hand side. We don't work directly with professional and vocational licensing. We liaise with that office, but if you were to call the RICO office, you would actually get us in an entirely different building than professional and vocational licensing. All right, so who does what? In a nutshell, boards, commissions, and programs are going to set policy and make rulings on disciplinary matters. Licensing division is going to disseminate licensing information, handle applications and renewals. And RICO is going to receive complaints, referrals, and tips, investigate and prosecute violations, and provide license and complaints information to the public. A lot of times, licensees will call and say, "You revoked my license." And our response is usually, okay, RICO didn't revoke your license. What RICO did was initiate a disciplinary proceeding against your license, which may have been heard by a hearings officer, which may have resulted in a board or commission revoking your license. RICO doesn't make disciplinary decisions on its own. The decision maker in our cases is going to be a board, commission, or a program who's either going to issue a final order or approve a settlement agreement in a RICO case that we have brought. So in a way, we act almost like the prosecutor's office in terms of taking a case before a board, commission, or program. Right, RICO is a dual enforcement system. And that means that we are investigating and prosecuting licensees before the boards, commissions, and programs. In those cases, the ultimate question is whether or not the licensee is fit to hold that license. What RICO also does is the investigation and enforcement of unlicensed activity in the state of Hawaii. A lot of that is going to be in the area of unlicensed contracting, but in the time that I've been at RICO, we've also seen unlicensed practice of nursing, unlicensed practice of medicine, unlicensed engineering work, unlicensed cosmetology activity. It always kind of amazes me what people will think they can get away with when they first move to the state. A lot of times with the healthcare unlicensed cases, hopefully it's a situation of an individual who has just moved to Hawaii, has applied for a license, but has not been approved for that license yet. But unlicensed activity can occur across all 49 industries. Right, so let's talk a little bit about violations on the licensing side. Okay, violations of licensing laws and rules. Each board commission program, each industry is governed by their own set of licensing laws and rules. The licensing laws are going to vary based on the industry that you belong to. So, for example, the requirements for a physician are going to be different than the licensing requirements for somebody registered with the travel agency program. Likewise, the disciplinary pieces are going to differ as well according to the industry. If a travel agency fails to deposit monies into a client trust account, that's a very serious violation for a travel agency. But on the nursing side, the nursing laws may never have addressed what happens on allegations of theft of money. So the licensing laws are really going to be tailored and depend on the industry that RICO's looking at. So again, if RICO files a petition for disciplinary action, which is the charging document for an action against the licensee, a hearing is going to be conducted by a hearings officer that's administratively attached to the department. A board or commission, again, is going to be the ultimate decision maker. Again, RICO is not taking licensing actions on its own. Cases can be settled, and settlement must be approved by a licensing board or commission. We do settle a fair number of matters with our office, and the reason for that is what we're covering is a very broad range of typical violations. So, for example, on any given day, a staff attorney can be working on a case involving a motor vehicle mechanic who fails to give a written estimate to the consumer before starting work on the car. As staff attorney can also be working on a case that involves allegations by a healthcare professional of improper touching or sexual assault. So because of the wide range of cases that we deal with, a lot of the violations that can be addressed by monetary fines or lesser sanctions are going to get resolved through settlement agreements, short of going to a formal disciplinary hearing. Examples of violations that we see for licensees, criminal convictions that may be related to the profession, practicing without a current license, or failing to complete continuing education. On the unlicensed side, RICO investigates and prosecutes unlicensed activity in the circuit courts. So RICO has to prove that the defendant was engaged in work for which a license was required. So, for example, if it's an unlicensed contractor, it's performing contracting work when a license is required, unlicensed plumbing, unlicensed massage establishment are examples of cases that we see a lot in the unlicensed arena. In all those cases, what RICO has to prove is that the unlicensed person engaged in activity that a license was required for, and they simply didn't have that license. An unlicensed case can involve a licensee who has let their license lapse or has failed to renew a license over a given period of time. Unfortunately, we see a lot of cases where somebody was licensed 10 or 20 years ago and believes that just because they've gotten the initial license, that they're still good to go in 2016. So Sanctions in unlicensed cases are going to include fines, a permanent injunction issued by a court that prohibits the person from engaging in future unlicensed activity, sometimes restitution, and if the unlicensed person is advertising, we're going to usually ask for an order disconnecting the phone number. Usually unlicensed contracting, but we also see activity in this area, unlicensed cosmetology, unlicensed massage, lots of unlicensed areas. All right, so how are cases initiated? Consumers can file complaints with our office. And in fiscal year 2015, we probably received over 7,000 inquiries to our office. We also get information from law enforcement and other oversight agencies. We receive tip information. We conduct sweeps and stings. And in all the cases, what we're trying to do is review the information to see if there was a possible licensing violation and sufficient basis to investigate. I can tell you, when you put complaints office in your office title, everybody finds your office. So on the times that I have actually covered phones in that area, I can tell you our intake folks deserve a special thanks every day. Again, lots and lots of inquiries to our office. Again, what we're really trying to sort out is if the conduct that the person is asking about actually constitutes a licensing law violation. One that we get a lot is I was made to wait 3 hours in my doctor's appointment in my doctor's office before I was seen for my appointment. That actually isn't a licensing law violation. So a lot of what we do when we take the calls over the phone is try to talk to people about what the licensing law violations are and to see if there might be a civil remedy or other kind of remedy that they may be able to pursue, short of filing a complaint against the licensee. Okay. And again, sufficient basis to investigate. All right, the investigation process, very briefly, field investigator. If RICO has determined that there's enough information for us to take a look at, it may be assigned to a field investigator who's going to interview witnesses, subpoena records, typical investigation process. They're going to work with the licensee for his or her side of the story, and that's a very important piece of the puzzle there. Another number that I'm going to give you is around over 5,000 matters where every year our intake investigators are working with the consumers who call in, and also many cases with the licensee that's involved with the complaint. So, for example, if it's a situation where a consumer calls and just wants a copy of their medical records, or just wants a copy of the invoice from their car repair, our intake unit is going to try to work with the consumer and the licensee to get that information made available, or to try to assist in resolution or getting the consumer to try to resolve that matter with the licensee. Sometimes it's just a matter of getting the licensee to come to the table and take the telephone call from the consumer. And in those instances, our office may be able to help with that. And what that really does is it assists our field investigators and our staff attorneys by freeing up time for them to focus on the cases that we really want to be focused on, where the allegations are serious and deeply impact health, safety, and welfare of consumers. Right, so a field investigator, again, is going to work with the licensee on his or her side of the story. There is something called the ostrich effect, which happens all the time, where the licensee will get a phone call or a letter from RICO and simply not respond. And we do try to tell licensees, come in and work with our office. And the reason for that is a high number of cases can be resolved if we get information, clear up any kind of misunderstanding, try to get the parties to work with each other. And a field investigator may also consult with an advisory committee member, which is an expert appointed by the board commissioner of the program. And why that's important to us is every staff attorney is not an expert in the field of medicine, the field of nursing, and the field of motor vehicle repair. And we do rely very heavily on licensees to assist us in explaining what may have happened in a case. Field investigators can also work with complainants and respondents to resolve issues at the field investigation stage. Talking about a little bit about the disciplinary process, if there's sufficient information and if there's been a determination that a licensing law may have been violated, then the case may proceed on to our legal section for evaluation and assignment to a staff attorney. Staff attorneys have a very difficult job at RICO. They handle a high number of cases every year on both the licensing side and the unlicensed side. And again, what we're really trying to determine is whether or not there's sufficient information for the office to proceed on. Legal action on the licensing side is again initiated with the filing of a petition for disciplinary action. Cases can be settled or it may proceed to a hearing at that point. And sanctions can include fines, continuing education, suspension, or license revocation. As a board member, you may see a settlement agreement or a hearings officer's recommended order come to you for your review and your consideration. And I will tell you from the RICO perspective, we've worked very, very hard in the past years to try to make sure that we're recommending outcomes that are meaningful and effective for the case that's before us. So you may see a settlement agreement where we are recommending probation, maybe a monitoring agreement if there's drug or alcohol or substance abuse allegations involved. There's a number of different sanctions that we may recommend to make sure that a good result happens for everyone involved in the licensing case. Okay, the question I get from licensees all the time is what information is available? RICO also operates a phone bank that operates every morning from 7:45 to 4:30 every day. What we do is we take telephone calls from consumers and we provide them with information about verifying whether or not a license is current and active, and also giving complaints history information, which is if our office has received a complaint or taken formal legal action against a licensee or unlicensed person, we provide that information as well. In any given year, the phone bank is taking probably about upwards of 44,000 inquiries in fiscal year 2015, in terms of telephone calls. And those are folks that are asking for checks on licensing, complaint history. We also give business registration information and information from the Office of Consumer Protection's complaint history information as well. All of the information that the DCCA provides is also available 24/7 on the website. So, and predictably, as more people find their way to the website, the number of calls will hopefully decrease to the RICO office. And I can tell you that licensing and verifying licensing is a very, very important service for licensees. Medical credentialers, insurance companies, in addition to consumers, we're doing a lot of license verification, not just for the general public, but also for industries and industry entities that licensees are dealing with. Right, so again, consumers can verify a license by checking the professional vocational licensing search or by calling our office. They can check complaints also from the RICO website. Right, one of the things that we do try to do, again, when we're dealing with the high volume of cases that we have coming into our office, what we do is try to push for education for the licensees. And the reason we do that is if we can get the licensees to conform with some very, very simple things, to get their continuing education done on time, to provide verification of the continuing education when the executive officer is requesting it. What it does is it frees up time for us, again, to focus on the cases that are of serious concern to us. Right, so one of the things that we do, again, a lot of consumer education, a lot of licensee education outreach to any trade group that will ask us to come and present. We will try to accommodate that request. So one of the things that we've been doing recently is 10 things we can do for licensees, 10 things you can do for licensees. And the first one being renew your license on time. Renew your license on time. I can't say it enough. Renew your license on time. You know, what you don't want is for a consumer who's thinking about hiring you to check the RICO website or check the professional vocational licensing website and find that the license is not current. So licenses always typically renew around the same time. And what we tell licensees is not only your license, but the licensees of anyone that you are supervising, because you don't want to be in a position where you may be aiding and abetting an unlicensed person doing work. Number 2, take the time to renew your license yourself. Renewal applications are supposed to be completed by the licensee, and they actually include a certification that the licensee has read all the statements and that all the statements are true and correct. We had a very interesting case that involved a physician whose wife was actually the office manager. And the wife had gone online to the electronic renewal and had renewed the license and had indicated that the licensee had not had any criminal convictions in the last year. Turns out, husband had actually had a criminal conviction in the last year, but had not shared that information with his wife/office manager. And that's a case where RICO actually investigated and prosecuted based on a misrepresentation by the licensee on the license, because the licensee is supposed to be certifying that the license information is true and correct. And why it's a serious thing is because that's what the licensing boards or commissions are relying on when they renew a license application. Right, continuing education, just do it. Just do it. If you haven't done it, don't say that you did. If you're required, do it. Don't wait until the last minute. Keep your documentation. Very, very important to keep documentation and proof. And if you didn't do it, what we tell licensees is contact the licensing authority and ask what you can do. Because I do think that the worst thing you can do is certify that you did it when you actually aren't going to be able to provide proof. Right, number 4, report change of address information. It's required by statute. It is the licensee's duty to provide written notice to the licensing authority of a change of address within 30 days. And the reason why that's important is because as a board commissioner program, you don't want to spend all your time trying to track down licensees. They're required by law to update their address information in writing within 30 days. All right, number 5, familiarize yourself with the licensing laws and rules, including Hawaii Revised Statutes, Chapter 436B, that's the Uniform Professional and Vocational Licensing Act. Any rules that a board, commission, or program has adopted, and anything incorporated by reference in laws or rules. For example, a reference to the American Medical Association's Code of Ethics. So we encourage all licensees to once a year pick up the licensing laws and rules, make sure that your business practices are conforming with the requirements out there. Number 6, tell licensees to stay within the scope of their practice. Scope is established by laws and rules, and what it really does is it delineates what a profession does and places limits on the functions persons within a profession can lawfully perform. And we see this across the board in a lot of different areas. If you are licensed as an esthetician, that doesn't mean you can cut hair. If you are licensed as a plumber, that doesn't mean you can remodel a house. If you're licensed as a nurse, that doesn't mean that you can perform all the functions that a licensed physician can. So scope of practice is very, very important for licensees. And what we do encourage all licensees to do is if they have a question about scope, to contact the executive officer of the board and ask whether or not a board or commission has issued an informal opinion about any kind of scope question. Right, number 7, comply with other Hawaii laws. So in addition to the licensing laws and rules, other laws may include zoning, occupational health and safety, especially important for contractors. Sanitation, especially important in some of the beauty and other healthcare industries that are similar to that. Taxes, especially if the licensing law is going to specifically require you to provide proof of compliance from the Department of Tax. And number 8, don't hire or recommend unlicensed people. It's important for licensees to know when a license is required. For example, if you are a real estate salesperson and you're engaged in property management, it's important for you to not hire unlicensed contractors, unlicensed guards, unlicensed landscapers when a license is required. Licensees should verify that the person that they're recommending or hiring is actually licensed. And don't be left with an unhappy or unsatisfied consumer. Because what we tell licensees is, if the unlicensed contractor, for example, disappears, who do you think the consumer is going to find? The licensee that's still working in the state. Number 9, keep good records of money received, disclaimers you've given, depending on the license that you have. Anything the law requires you to provide a consumer, estimates, warranties, etc. What we do warn people is you got to be consistent and you have to be accurate. Right, and again, talking about that ostrich effect, number 10 thing, the 10th thing that we tell licensees, very, very important. When you get a call from RICO, think about the 5,000, 6,000, 7,000 matters that our office has been able to attempt to resolve between consumers. The last thing that you want to do is ignore a petition for disciplinary action, a notice of hearing, a citation. I do usually tell people that the state of Oregon's Bar Association did a study a while back. And what they said was, in terms of disciplining attorneys, 50% of the attorneys who lose their license in Oregon lose it because they don't show up. So what we really tell consumers is, if you get a call from the RICO office, try to work with us, especially in terms of giving your side of the story. Again, when you hold yourself out as the complaints office, who do you think is going to file complaints with you? Lots of people. And what we really do try to do is get the licensee's side of the story and try to figure out if there isn't some matter that we can't try to help resolve, or if there really is a licensing law violation involved at all. All right, thank you for coming today. I do want to put out that I am available by phone or to meet with the boards and commissions as needed. If you have questions about the RICO process, about our office, or how we are trying to address a particular issue, my door is always open. And I do invite board and commission members to work with their executive officers to reach out to RICO on questions that you may have. Thank you.
Thank you, Daria. Okay, at this time, I would like to call up Cheryl Kakazu Park, Director of the Office of Information Practices. She'll be talking about the Sunshine Law and the Uniform Information Practices Act.
Okay, good morning, everyone. Mahalo for coming today and taking this training. I think that most state and county government employees know what the Office of Information Practices, or OIP, does, but many people who are just volunteering for boards coming out of the private sector don't, because these laws apply to government agencies and boards. Please don't get us mixed up with the Governor's Office of Information, which takes constituent complaints. As the Office of Information Practices, we are an independent state agency that promotes government transparency and accountability by protecting the public's right to open meetings and open records. primarily through the Sunshine Law, which is Part 1 of Chapter 92, as well as the Uniform Information Practices Act, or UIPA, which is Chapter 92F. And both laws apply to nearly all state and county government agencies and boards. The fact that you're here today probably means that you're subject to one or both of these laws. And you need to know about these laws because if you violate them, members of the public or media would complain, and so your board meeting may have to be canceled, or you might find yourself on the front page of the paper with people complaining about your actions. Your agency or board may face adverse OIP and court decisions, and your board could have its final actions voided by the court. There may be fines and attorney fees and costs to pay after years of litigation. Intentional violations, which are rare, could even subject you to a misdemeanor that's subject to punishment by up to 6 months in prison, or you could lose your immunity from civil or criminal liability, or you could be removed from the board. And to help you stay out of trouble, OIP proactively provides a lot of training online that is available to you 24/7. Today, I'm going to try to condense 3 hours worth of training, basic training that we have on the Sunshine Law and UIPA into 30 minutes. So I'm going to go by it very quickly, but whatever you miss, you can always go online and look up again. So let's start the training by looking at what the common policy is, that the Sunshine Law and the UIPA were both enacted with this common policy, where the legislature said, in a democracy, the people are vested with the ultimate decision-making power. Government agencies exist to aid the people in the formation and conduct of public policy. Opening up the government processes to public scrutiny and participation is the only viable and reasonable method of protecting the public's interest. Therefore, the legislature declares that it is the policy of this state that the formation and conduct of public policy, the discussions, deliberations, decisions, and actions of government agencies shall be conducted as openly as possible. The Sunshine Law further expressly states that it is the intent to protect the public's right to know, and it directs the provisions requiring open meetings to be liberally construed while providing for exceptions to be strictly construed against closed meetings. So now you know why OIP interprets the laws the way we do, and how you should be conducting your government business in order to comply with these laws. Let's talk about some of the specific requirements of the Sunshine Law, which applies to state and county boards, and that includes you, commissions, agencies, authorities, county councils. Doesn't matter what you're called, if you're considered a board under the Sunshine Law, you better follow it. And then it also applies only when board members are discussing board business. So because the Sunshine Law only applies to board members, it does not apply then to non-board members, such as the general public, lobbyists, reporters, government officials, or board staff, unless they are being directed by a board member to participate in serial communications, in which case you could have a problem on your hands. The Sunshine Law only applies to board business, which means specific matters over which the board has supervision, control, jurisdiction, or advisory power, which are currently or reasonably anticipated to come up before the board in the foreseeable future. So board members can talk to each other about social matters, their private jobs, their kids, the weather, hurricanes, whatever. Board members can also talk to each other about board business that's closed and is not going to be coming back before the board in the reasonably foreseeable future. But don't talk with other board members about board business that's currently before the board or will be coming up in the foreseeable future. Now, the Sunshine Law requires the board and its subcommittees to conduct all board business in the open, and it has the following basic requirements. The main rule to remember is that discussions, deliberations, and decision-making on board business by more than 2 board members can only occur at meetings open to the public. So I'll talk in a little while about executive sessions, which are board meetings that are closed to the public. But even with executive sessions, you must meet the Sunshine Law's requirements for notice, agenda, testimony, and minutes. So for any Sunshine Law meeting by a state board, written notice must be filed with the Lieutenant Governor's office at least 6 calendar days in advance of the meeting, and it must include a sufficient agenda that describes what you're going to be talking about so that people will know whether or not they want to attend and provide testimony. When you file your agenda and what you say in it are very important, and this is where boards often get tripped up. And if you do, you might end up having to cancel your meeting. The worst case scenario is you go through litigation and have the court void your final action. So be careful about all of the Sunshine Law's requirements. Now, you could amend an agenda, but that's only with a 2/3 vote of all members to which the board is entitled. No agenda items can be added if it is of reasonably major importance and your action on it is going to affect a significant number of persons. So it's not easy. Now, an open meeting must provide any interested persons with the opportunity to testify, and whether it's orally or in writing, on any agenda item, but they cannot ask questions of you as board members. How you write up an agenda is important because it can either expand or limit the scope of testimony. There is no right to testify on an item that is not on your agenda. Conversely, there is a right to testify on an agenda item. Now, you don't have to have a general comment period for each agenda or each meeting, a soapbox period where people can talk about anything. If you do have that on your agenda, then you're going to have to let people talk about anything. If the board anticipates going into executive session during the meeting, then the agenda should state the statutory reasons for going into such a closed meeting and describe the items that will be discussed during that meeting without actually compromising the purpose of closing the meeting. So even if the public cannot attend the executive session, they must be given the opportunity to testify and comment on those items beforehand. Now, in addition to timely notice and a proper agenda, minutes must be kept. Oops, I'm one behind. Oh, wait. Minutes must be kept, and they must be a true reflection of the matters discussed at the meeting and the views of the participants. Transcripts are not required, but you could use them as your minutes if you prefer. The minutes must record all of the members present or absent at the meeting and all of the votes by member. A board member's right to request that specific information be included in the minutes only applies while the meeting is actually taking place. The board members cannot wait until after the meeting is over and then insist that the minutes be amended to include additional information. Minutes of the meeting must be available within 30 days after the meeting. There is no requirement for the board to first approve the minutes before they can be released to the public. If more than 30 days has passed after the meeting, then the unapproved draft minutes must be released upon request. Be careful about circulating draft minutes to board members to review and make changes in advance of the meeting at which they will be approved. To avoid potential problems with serial communications, board members' comments and revisions to the minutes should not be directly circulated by the member to the other board members. Use your staff. Changes can be made and incorporated into a revised draft of the minutes by the staff for distribution to the other board members. Although the Sunshine Law requires boards to release their minutes within 30 days, this is where you also have to know your UIPA responsibilities, because the public can actually request that they receive the tape recordings or draft minutes, and under the UIPA, you would only have 10 business days to respond. And I'll talk more about the UIPA very briefly at the end. Now, the Sunshine Law permits the board to hold a closed meeting and go into executive session only for 8 specific purposes. You cannot close a meeting just because it's going to be about personal information or you think it's confidential or embarrassing. The board can only go into a closed executive session for 8 statutory reasons as follows. The first reason is to consider and evaluate personal information of individuals applying for professional and vocational licenses. Voila, that's you guys. The second would be to consider the hire, evaluation, dismissal, and discipline of an officer or employee where considerations of matters affecting privacy are involved. A third reason is to deliberate the authority of persons designated by the board to conduct labor negotiations or the acquisition of public property. A fourth reason is to consult with the board's attorney on questions and issues pertaining to the board's powers, duties, privileges, immunities, and liabilities. A fifth reason is to investigate matters concerning criminal misconduct. A sixth is to consider matters relating to public safety or security. 7 is to consider matters relating to the solicitation and acceptance of private donations. And 8 is to consider a matter that requires the consideration of confidential information under state or federal law or court order. These are very specific reasons that you have to meet. And assuming you have met one of these reasons, the board also has to follow very specific Sunshine Law procedures to convene an executive session. There must be a public announcement of the purpose of the executive session, so it must be on your agenda. The board must also take an affirmative vote at an open meeting of 2/3 of the members present, who also constitute a majority of the members to which the board is entitled. So if you have 12 members on your board, then 2/3 would be 9 people, and they would also be a majority of the 12. But say you only have 9 members that are either appointed or that show up at the meeting. In that case, you would need 6, because 2/3 of 9 is 6, but then you would need an additional vote, 7, to make it a majority of your 12-member board. And the vote to go into executive session must be recorded in the minutes. Now remember that the Sunshine Law requires minutes to be taken, even of your closed executive session. So executive session minutes may be kept confidential only for so long as their disclosure would defeat the lawful purpose of having a closed meeting. Therefore, at some point in time, The executive session minutes may have to be publicly made available if disclosure would no longer defeat the purpose of having the closed meeting. For example, executive session minutes to discuss the planned purchase of land could generally be disclosed once the transaction is completed. On the other hand, if the executive session was closed because of the personal privacy of an employee who was being evaluated, then the minutes will still not have to be disclosed even after the executive session has ended and the employee is no longer there. If someone files a complaint, OIP can look at the executive session minutes in camera, or meaning confidentially, and will look to see if the board actually engaged in discussions during the closed meetings that are only related to the purposes for that closed meeting. Now, besides regular meetings, you have special meetings called limited meetings, where the Sunshine Law requirements are different because they allow boards to hold a meeting at a place that's not open to the public. For example, HART might want to go to an active construction site, or the Historic Preservation Board might want to go into people's homes to see if they should be included on the historic preservation list. In which case, the board must meet in a regular meeting first and vote by 2/3 of all members to which it is entitled to have a limited meeting for the following purpose. Either the meeting location is dangerous to health or safety, or the inside inspection is necessary and public attendance is impracticable. And you will also need to get my concurrence as the OIP director, and the forms for the concurrence are on our website. As with regular meetings, the board for a limited meeting must provide 6 days advance notice, and it must keep minutes of the limited meeting. And unless I waive the requirement for the board to videotape the meeting, then the video must be made available at the next regular meeting of the board. The board cannot make any decisions at a limited meeting. So boards, what they might do is hold a limited meeting, and soon after that, schedule a regular meeting where they can accept testimony and they can deliberate, discuss, and make decisions. Another type of meeting that's possible is an emergency meeting, but of course, they also have special Sunshine Law requirements. And you can hold an emergency meeting with less than 6 days advance notice if, one, there's an imminent peril to public health, say like the upcoming hurricanes, or two, there's an unanticipated event requiring the board's action on a matter over which it has jurisdiction. The board must give written reasons for its findings of an imminent peril or an unanticipated event. And 2/3 of all members to which the board is entitled must agree to the findings and that an emergency exists. In the case of an unanticipated event, the Attorney General, not me, the Attorney General must also concur that the statutory conditions are met. An emergency meeting agenda and the findings must be filed with the Lieutenant Governor's office and in the board's office, and persons requesting notification on a regular basis, like people on your mailing list, should be notified as soon as possible. So anytime as a board member you find yourself talking with another board member about board business and you're not in one of these open meetings that I just described, then you have to stop and think. Because remember, you cannot talk, you cannot send memos or emails, you cannot text, post, Facebook posts or tweets or poll or engage in serial communications on any board business. But there are 8 permitted interactions which allows certain conduct outside of meetings. And the first permitted interaction allows 2 board members to discuss between themselves board matters, as long as there's no commitment to vote or sought, and no commitment is sought, and the 2 board members do not constitute a quorum. But remember that serial communications are still prohibited, and that's where member A cannot go and talk about something to member B, and then member B talk to member C, and member C talk to member D. You can't engage in that type of communications. A second type of permitted interaction where you can meet outside of a regular open meeting is where you've set up an investigatory PIG, or a permitted interaction group. And this is where the board has to follow specific procedures to set up the PIG, and it requires 3 board meetings. At the first board meeting, the board can set up a PIG that would investigate a certain board matter. For example, you might want to have confidential interviews with people you want to hire, or inspections, or product demonstrations, or something considering confidential information. But you have to set up the scope of the PIG's authority at the first board meeting. Then the PIG can go off and decide, discuss the matter. They don't have to send out any sunshine law notices. They don't have to be set up as sunshine law meetings. And when they finally come up with their findings and recommendations, that's when they have to go to a second board meeting to present those findings and recommendations. But at the second meeting, the board still cannot discuss or decide on the recommendations. It's not until everybody, including the public, has had a chance to review these findings and recommendations that the board can host a third board meeting, at which time it can take testimony and it can do its normal discussion and deliberation and decision-making on the PIG's findings and recommendations. So that's for an investigatory PIG. There's also a negotiating PIG, which doesn't require the 3-meeting, doesn't have that 3-meeting requirement. So a negotiating PIG can be set up to present, discuss, or negotiate any position that the board has adopted at a board meeting. Now, a fourth type of permitted interaction allows 2 or more board members, but less than a quorum, to privately discuss the selection of the board's officers. But again, remember, no serial communications, because this was the exact situation which the Hawaii Supreme Court found in the Right to Know case violated the Sunshine Law's spirit. And the 5th permitted interaction allows the board to meet with the governor in private over matters that the board has no adjudicatory function. So, and now I moved ahead to the 6th permitted interaction, which is meeting with the head of the department to which the board is assigned. So you can talk about your budget or your personnel or purchases of supplies and equipment and things. The 7th permitted interaction occurs when a meeting is canceled due to a lack of quorum, or because you might have problems with your interactive conference technology. Now, because people have showed up to testify perhaps, the board can continue to receive their testimony and presentations on agenda items, and it can question the testifiers, but it cannot deliberate or make any decisions because the meeting has been canceled. So instead, the board members present must create a record of what went on and include the written testimony and present it at the next board meeting, where then the board can discuss and deliberate on those agenda items. And then the final permitted interaction is for informational meetings where you have less than a quorum of board members attending. And this is one where you can actually talk about board business, so long as the meeting or presentation was not specifically and exclusively organized for or directed towards the board members. Here, people were concerned that a developer, for example, would set up a private function for board members and call it an informational meeting with less than a quorum. You cannot do that. While discussions of board business may occur as part of the informational meeting, you cannot have any commitment to vote, or you can't seek such a commitment. And at the next board meeting, the members that attended have to report what went on, the board matters that were discussed, and who was there. So this type of permitted interaction allows less than a quorum of members to attend a meeting of, say, the legislature, or a convention, seminar, or another community group's meeting. But remember that you can only use this if you have less than a quorum. If you have more than a quorum going to a conference or something, you better talk to OIP first. Legislative hearings present a real challenge to Sunshine Law boards because of the shortness of time. You know, you don't have 6 days to notice your meeting to discuss legislative issues. But that's why we have a special quick review and guidance that we have on our website that gives you ideas on how you can handle this, many times using your board staff to help you out. So that's a very quick overview of the Sunshine Law, and I'd like to just go very briefly into the UIPA. And the UIPA makes all government records, which are maintained by agencies, open to public inspection and copying upon request, unless access is restricted or closed by law. So a government record means information maintained by an agency in written, auditory, visual, electronic, or other physical form. So emails that you send to the board and that are maintained by the board are going to be included. And agency also means boards. So agency covers any unit of the state or county government. So that includes boards, commissions, and even the legislature. Now, there are 2 types of government records. One is a public record that must be disclosed to any member of the public under Part 2 of the UIPA, unless certain exceptions apply. And the second are personal records that are disclosed under Part 3 only to the person about whom the record pertains, unless an exemption applies. And Part 3 really gives an individual special rights to access and seek correction of government records that are about him or her. And these rights are not available to the general public. The records must contain or make reference to the requester's name, social security number, or some other type of identification of that person. And while certain records, such as a complete personnel file or a witness's statement, would not be available as public records open to other members of the public, the person about whom that record pertains would have the right to see and correct them, subject to certain statutory procedures. So, within 10 business days, the UIPA requires an agency to provide the requested records or to provide a notice or acknowledgement saying why they're not going to be doing so or when they're going to be doing so and how much it's going to cost the requester. Generally speaking, board members won't have to deal with the UIPA because it's your board staff that's going to be handling these requests, but you need to know about it because ultimately you're responsible. So to keep you out of trouble, OIP encourages the boards and its staff to use the UIP record request log, which we developed, to help you agencies comply with the law and keep track of the requests that it does receive. And training is available on OIP's website. So this is what our website, the homepage of our website looks like. And to get there, you just have to log in oip.hawaii.gov. If you're feeling pretty good, like you think you know the Sunshine Law, we even have a Sunshine Law quiz that's available on the website. We have many other Sunshine Law and UIPA training materials, and we have all of our formal opinions that you can search by subject matter in our subject matter index. And then we send out these What's New updates about the Sunshine Law and UIPA, which are kept archived on our website, or if you're not getting it through your board, then you can email us, and be placed on our What's New list. If you don't find what you need on OIP's website, OIP can also work with the agencies to provide additional advanced training, and you can call OIP. We have our Attorney of the Day service, so we can answer general questions, usually the same day. And here are our contact information. So mahalo for your time and attention and for your service as volunteer board members. Okay.
Thank you, Cheryl. At this time, I would like to call up the Honorable Rosalind Baker, State Senator from Maui. She has conducted all of the confirmation hearings for the PVL board members. So I know you all are familiar with Senator Baker. Welcome, and thank you for participating today.
Thanks, Celia. It's a delight to see all of you here today when we were worried about Matilda and then Lester coming by. But I just wanted to say aloha and welcome to your state capital. And mahalo to DCCA for providing our new and some returning board and commission members to an orientation and training. I appreciate their invitation to share a few thoughts with you. And at the end, I'd be happy to try to answer any questions that you might have about the legislative process or some of the intrigue that goes on in the Capitol. No, not really the intrigue, but some of the legislative process. I'd be happy to try to provide additional insight or answer some questions. I first want to thank all of you for stepping up to volunteer to serve on one of our many boards and commissions, vocational and professional licensing boards and commissions. Now, DCCA, from my perspective, since I have DCCA and health, or have consumer protection and health this year, DCCA has the lion's share of the boards and commissions. And so they have a very well-defined system. They have executive officers who work sometimes with several boards and commissions, but they really know the law, they really know the statute very well. So you're very lucky to be a part of a board or commission that DCCA handles, because they do an excellent job and they do it very well. I'm curious, how many of you are brand new board members? Okay. How about any returning board members who just wanted to brush up? How many of you are public members? Any public members here? I see a hand in the back. Very good. You know, it's nice to see some of you in person. Some of you I know only by talking on the phone, because we can only begin our confirmation process when we actually get the names and contact information from the governor's office. And sometimes it comes as we're trying to race through and finish up bills, crossing them over to the House, coming back and getting ready for conference. So I've used in the past the ability to connect with people on the phone, so particularly neighbor island folks don't have to fly over to interact with the process. But I've gained a lot of insight from those conversations. So even if it's just a 5 or 10 minute conversation, you've really helped inform the work that our committee does and to understand a little bit better about some of the issues that you see that are coming before the boards and commissions, and that's always very, very helpful. So I welcome your feedback. Afterward, send me an email, call my office, to let us know if you think, having been through the process now, maybe some of you a couple of times, how you feel about it. Was it meaningful for you? Are there things that our office could do to better support you as you're going through the process? Because I know as a new board member, it sometimes can be a little daunting. You know, the legislature is over there. You know, what does it mean to be confirmed? Are they going to be nice to me? Because sometimes you see some of our confirmation hearings on television, and maybe we're not on our best behavior. But it is a formal process, and it is required. So we must do the best that we can to make sure that all of our board and commission members are in the right slot. They're either a licensee or they're not a licensee and not part of that profession if they're serving on that board as a public member. And our public members are very, very important, because the bottom line for all of our boards and commissions is you are there to help make sure that the public is protected. Not necessarily that any of our licensees would ever want to do something untoward, but sometimes people get caught up and we're not doing all that we can to make sure that the public is protected. I think all of you know that it's the legislature, through the bills that become law, that set the various policies that are implemented by the executive branch. And as a professional vocational licensing board member, you are actually carrying out an executive function. So I thought it might be helpful to share some of the kinds of bills that we pass and become law that impact the work that some of our boards and commissions do. So I just went back through our legislative highlights that the Senate Majority Attorney's Office does for us, just to give you a sense of some of the bills that passed that really impact how the boards work. First was the nurse licensure, letting them join an electronic system. That's going to make it easier for the Board of Nursing to keep track of all of the nurses that may be coming in and want licensure. And before we passed this statute, they really weren't able to utilize an online system, at least a national online system. We also had some clarification in the massage therapy statute about what constitutes a violation. And we found from talking with the boards and commissions that the threshold for some very not severe licensing violations was taking a very long time. And so it was really an inappropriate way to handle some of these violations. So we actually lessened them and changed the law. We also, at the nursing board request, provided for criminal history record checks. You would think that all of our upstanding licensees would not have to go through this, but we do get people coming in and they're not disclosing, so we need a way to verify, because you don't want somebody who has done something that's criminal in nature being closely in contact with a patient or with somebody in a very vulnerable situation. And that came from the profession themselves. We also provided some additional investigators for the Office of Consumer Protection, because we think that's important that there be some parity there so that we can be ensured that that side of the house is working as efficiently and effectively as they can. And then we also provide for some new professions. We have registration and licensure, and for veterinary techs, we provided a registration system. We changed the scope of practice and authority for some advanced practice registered nurses. We gave them the ability to be primary care providers a number of years ago, and every year we find another statute that doesn't say, doesn't include them appropriately, and the legislature has to go back to change. So all of our laws are really living, breathing activities, and they don't get set in stone. There can be amended, sometimes yearly, it seems. We provided some additional peer review for the Board of Accountancy, the use of the term licensed for marriage and family therapists, some licensing requirements changes for social workers to make it easier for social workers on the neighbor islands to make sure that they could be licensed in a setting that was appropriate for them. So these are some of the examples of some of the kinds of statutes that we end up with, trying to make sure that the boards and the professional vocational licensing boards, the scope of practice for the professions under their jurisdiction, are actually keeping up with the times and keeping up with new educational requirements, with new federal requirements, sometimes reimbursement requirements. And we know that, at least in the healthcare arena, technology and the standards education are changing so rapidly that our licensing standards have to change too. One of the professions are, I don't know whether it's probably a vocation as opposed to a profession, but our guarding industry has really taken off. And we made some changes in that arena several years ago, and we're still kind of working through that. But it's very important that anybody in a position of trust be appropriately trained and licensed. I want to just underscore that as a board member, your responsibility is first and foremost consumer protection. And one of the areas that we needed to do a little bit better in that area had to do with some of our healthcare licensees. We had an instance where some of our licensees were not performing appropriately, or some had come in and not disclosed that they had a violation that kept them from being licensed in the state in which they originated. Come to Hawaii, they want to be licensed here. It's very important that the board, that RICO, have the appropriate information to make sure that if you're not qualified to be a licensee in another state, Hawaii doesn't necessarily want you unless you go through some additional education, some training, and some vetting. We really don't want whether it's a nurse, a doctor, a dentist, a beautician, anybody else who couldn't be licensed in another state and meet our standards because of some wrongful act. They shouldn't be allowed to practice. So we passed legislation, it's now Act 38, that gives RICO and the board some additional tools and allow them to vet these individuals in a more timely fashion and to deny a license, so we don't run afoul from some of the concerns that were in that North Carolina case before the Supreme Court that Bryan talked about earlier. But it really gives us a good solid founding for turning inappropriate folks who ask for licensure down. The other thing I'd like to encourage all of our new board members is to don't be afraid to speak up and to ask lots of questions. In our business, there really are no dumb questions. And so it's important that if there's something that you don't understand, particularly if you're a public member or if you're on a different aspect of, some of our boards have lots of different professions. ISLA, let's see if I can remember what ISLA stands for, engineers, architects, landscape architects, and surveyors, I think, is part of that one board. And so they have different standards, they have different licensing requirements, and so you might be sitting on a board like that crosses several different professions or different trades, and you may not understand everything because you're coming either from a public standpoint and you don't know much about that particular industry, or you might be a different kind of licensee. So it's important that you don't be afraid to ask questions, that you, if something doesn't make sense to you, ask your executive officer, ask your fellow board members, ask your deputy attorney general that's sitting in with you, or some of the other staff, so that you can be clear, because the decisions that you make as board members are very, very important. And we want you to have the best information and understanding that you can. And so you've got very good resources at your fingertips. Don't be afraid to ask. Don't be afraid to use them. The final thing that I wanted to share with you before I take any questions that you might have is to make sure that you become familiar with the Capitol website. It's www.capitol.hawaii.gov. And I got a little brief handout. I think maybe staff may have provided it to you already. That's sort of the screenshot of the homepage. And on this website, there's just lots and lots of information. You can find out what the legislative calendar is. You can see other people's testimony on bills. You can communicate with your legislator or with anybody in the legislature on a particular bill or on a particular item that's coming up. You can see the committee reports, you can see who testified, you can see how the bill changes over time, what bills get sent to the governor, what the governor's actions are on them. And it's really your way to interact with us. And so I hope you'll explore the website. Got lots of information. It's right now would be information from the session past, but when we open in January, the third Wednesday in January is our opening day, it'll start to be populated with the new bills that get introduced, and everything that was not sent to the governor this past legislative session is, as we would say locally, maki-dai dead. It's not happening anymore. We have to start over with new bills, and we start over from bill number 1 and go through. One of the most important bills for all of our departments is the executive budget, and that will, the Ways and Means and Finance Committee will start having hearings on that. All the departments, I'm sure, our director and Kat Awakuni and the Attorney General, because I know those two departments are here, have already started and probably already submitted their final request to the governor, and he's starting to put that together. But you can see all of the details and probably more than you ever wanted to know about the legislature from our website. We try to make it as user-friendly as possible, and I encourage you to take a look. Again, thank you so much for your willingness to serve. I look forward to seeing you around the Capitol, and if you do come down for a hearing or for some other business, I'd love for you to stop by my office and say hello. I've got terrific staff, and I know they'd enjoy saying aloha to you as well. So I'd be happy to take any questions that you have. If not, I'll turn you back to the moderator. Any questions? Yes. Oh, well, thank you. You know, I've been doing this a while, and I must say that I'm always impressed with the quality of people that step forward to serve, whether they're, you know, serving on their own licensing board or whether they're serving as a public member on others. And I'm impressed that some of you come so highly recommended that your executive officers say, can you put in a good word for this person, because we really want them and we really want them to continue to serve. So some of you, after you've served for your, I think, requisite two terms, you're term limited on that board, but you have an opportunity to serve on another. And I'll just make a pitch now, because we always need more board members. So if you have friends, associates who you think would be interested in serving on one of our boards and commissions, would like to do that. I know that Celia, Kat, some of the others can help you get your paperwork in. It's on, I think it's on the governor's website, and you can do it online. And we would really appreciate it because we're always looking for people who are willing to serve on our boards and commissions. Some of you will be worked to death, some of you not so much. But whichever kind of board you're on, the work that you do is important. We couldn't do what we do in the legislature. The executive could not function without good, wonderful board members. And so thank you all very much for your service. And I look forward to seeing you around the Capitol next year. Aloha.
Thank you, Senator Baker. At this time, I'd like to call up Bryan Yee again from the Attorney General's office. He'll be talking just for a few minutes about the role of the Deputy AG and role of board members. Okay, thanks.
So last time I was the only thing standing between you and a break, and now I'm the only thing standing between you and leaving. So thanks for the position here. I was asked whether I could talk about the role of the boards and commissions and the role of the AG, which I'm happy to do. There's both sort of everything and nothing to talk about in a way, because there's so much that we could say, but it really boils down to the fact that it is the role of the board and commission to make decisions. It is the role of the Department of the Attorney General to help you do your work. We don't actually make your decisions. We don't make policy. We advise you. We help you make that decision. We will provide you with information. We will tell you what the law says, but ultimately the decision will be yours. And that interplay between your Deputy Attorney General and the board is a very important one for us. It's also one that will differ depending upon the particular needs of the board and the particular board members. So some boards, really are very independent. They know what they want. They understand the law. They don't really require a lot of assistance. We are there as backup. We're there to be available, but they don't require so much from us except on perhaps some particular legal issues. Other boards perhaps may require more assistance. For those boards, we might tell them based upon historical knowledge, well, I can tell you this is what happened at this time. I can tell you what the rules say. I can tell you how the rules have been interpreted in other cases. We can tell you what has happened or how the rules and the law has changed. We can give you some of the historical knowledge that we have because we've done it for so many years, often with the exact same board. Ultimately, however, there's a line to be drawn between what we can do. Even if you wanted us to do more, we won't tell you, here's what you should decide, with certain very, very limited exceptions regarding violations of the law. But other than perhaps violating the law, we don't, there's a line past which we don't step across. The particular legal advice and assistance and support that we give to the boards includes we provide advice and counsel orally and in writing. So sometimes you need something in writing because you need to see that in front of you, and you need to study it, and you need to fully understand it. And we have a very special process by which our office will give written legal advice to our clients. It would involve us receiving a request from you. The deputy will be assigned to a deputy will draft a written letter. That letter will be reviewed by myself, We will then send it to the Attorney General. The Attorney General will review and countersign. It's possible the letter is actually referred to what we call our Appellate and Opinion Review Committee. So it would be submitted to them. The deputy and I would appear in front of that AOR committee to explain, here's what has been asked, here's what we have proposed as a reply. That is, for those questions that are very important, we do that. It is a little resource intensive. It takes some additional time. But on certain questions, that's what you need and that's what we will provide. Many other questions are more oral. They are simpler. They will be, there was this 3-hour presentation on sunshine law that was compressed into 30 minutes. What did they say? We're happy to be there to tell you. We do know the sunshine law. We understand the open records requirements. We understand the processes that are needed for disciplinary action, and contested case hearings. So many of those things we can help you with and answer for you. It's very good that you have some basic understanding, because the meetings, for example, are run by the board, not by the deputy AG. So we will lean over to the chair and say, don't forget to ask for public testimony. Or we might lean over to the chair and say, you need to get a vote for this. We may lean over to the chair and mention, oh, so-and-so left, you don't have quorum now, you have to hold on to the meeting. But that's just us giving advice. It's really the chair who's going to run the meeting itself. Just to let you know, sometimes you will ask for advice in open meetings. Sometimes the advice will be in executive session. As was explained, you may go into executive session to get legal advice from the Attorney General that's assigned to you. Sometimes you don't have to, sometimes you don't want to. Sometimes boards just want to blame the deputy chief for the advice, so they want it in open session. But that's your prerogative on how you wanted to do it. Assuming you do not get the advice in open session, the advice is confidential. It is privileged. You are our client, and the attorney-client privilege attaches to that advice we give you. Our office treats that very, very seriously. There is no deputy of mine who ought to be giving advice to you and then telling someone else, oh yeah, I told the board this, so don't blame me. No. If we give you advice and we say, here's our recommendation, and let's suppose you don't follow that recommendation, our office does not say, well, they didn't follow our recommendation, don't blame us. We will say nothing about what occurs in that executive session. Speaking of advice, by law, we are prohibited from giving private legal advice to you or to anyone else. So if you lean over to us and say, my brother-in-law got a speeding ticket, I can't help you. It's just not something we can do. We will help you interpret your laws and rules. We will review your draft rule amendments. The rules that are drafted have, and actually the legislation as well, have very specific formatting requirements that it's really a little unreasonable to expect the boards to be perfect experts on. So we'll review those. We'll review your draft minutes and responses to the public, as well as your agendas. You may have remembered that one of the requirements is that the agenda provide sufficient notice of what is being talked about. So, for example, there have been questions that have arose, and if you're going to propose rules, and those rules on the agenda, how specific do you have to be in the agenda to describe those rules? You can't just say rules about my profession. It's got to be. But on the other hand, it seems unrealistic to simply require that the entire rules be attached in hard copy to every agenda that gets passed out. So somewhere in between is, a decision needs to be made, and we will help you review that. Same thing for your minutes. Minutes have to discuss what happened to the meeting, but it doesn't have to be verbatim. How much or how little should be reflected in the minutes is something we will help you and your executive officer to work on. We will also help you review and draft contracts. We understand the procurement system. We will help your EO follow it. I know that sometimes some of these requirements can be very frustrating, especially to people from the private sector who come into government, and it seems perhaps like it's just a lot of obstacles that they have to overcome in order to do some of these things. Just understand that, especially with contracts, when we're using public monies, the public, these are intended for transparency and to make sure that public monies are being properly used and that people know that they're being properly used. So we have a lot of steps that have to be followed to make sure that that happens. And while it can be very frustrating for people in the private sector who are not used to this, who in their experiences might say, I got a guy, he can do this great, he's going to do a great price, low, it's going to do good work. What more do I need to do? And it's like, yeah, no, we got to go out to an ad. We have to wait for, we have to get an RFP. You have to draft the RFP. That's just something we have to do as a government agency. We will, as I said, make sure you're complying with all laws and rules, including the Sunshine Law. That will happen in the meetings. We will, and this hopefully it will be of limited relevance, but is nevertheless very important. We will defend and represent you if you are sued. So we are here to both keep you out of trouble, and if you get in trouble, to defend you and advocate on your behalf. So that, in a nutshell, is what our office does for you. How we execute it in any particular circumstance, we're certainly open for feedback from you as to what you need for your board, for your personal requirements. But if there are any questions, oh, by the way, one other thing. If you think we are not doing a good job, if you think we could do it better, we are open to suggestions. It's perfectly okay for you to tell either me, because I'm the supervisor, or any of my deputies, I need, you're not a board member, don't say so much. Or, you never help us. I mean, you stay so quiet all the time. And part of the problem, of course, is some boards want us to be quiet and some of them don't. And sometimes, and different board members within the exact same board may have exactly opposite views of what they want from us. So we do our best, but on the other hand, we're certainly open to feedback from all of you. So with that, if there are any questions, I'd be happy to answer them.
How does the Freedom of Information Act come into all this?
Technically, the Freedom of Information Act is a federal statute. We have a state statute called the Uniform Information Practices Act, which mirrors the Freedom of Information Act very, very closely. In fact, it mirrors it so closely we often use FOIA cases to understand what the UIPA requires, but it is, but the Uniform Information Practices Act is sort of the same thing for state documents. And so, is there a particular question you had about it?
No, just comes up every once.
Yeah, yeah, there's a lot to talk about, and so since we had a whole thing, I'm not going to talk about it some more, but if you had questions that arose, we are there to answer those questions, any particular questions you have. Or if you wanted more training for your board, we can do that as well. And if there's nothing else, thank you very much. Thank you for your service, and thank you for your time.
I would like to thank all of our speakers at this morning's session. We appreciate your time. We know you all have very busy schedules. I would also like to thank you, the board members, also for attending to this morning's session. I'm sure you have learned a lot within the past couple of hours. I want to say mahalo to staff who have assisted us with this, and thank you to Olelo so much for recording. And like I had mentioned earlier, it will be rebroadcasted, so I can email dates to your executive officers and they can forward the dates on. This concludes the session, and it is a little bit early, but I'm sure you gotta catch flights and stuff like that. So thank you very much. Thank you.